Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elawvate.net, ELAWVATE.net, or go online to elawvate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elawvate.net or fill out a case workshop request at elawvate.net. And Rahul and I will look forward to chatting with you soon. Today's episode of Elawvate is brought to you by the Expert Institute. Rahul, you guys use Expert Institute, right?
We do use Expert Institute, and it's fantastic to get different experts in different fields, but the best of the best. And you don't know until you do the research, and they do that all for us.
Today's show is also brought to you by Filevine. Filevine has a platform called Lead Docket, which is the state-of-the-art way of tracking all of your intakes and leads, particularly if you're putting money into advertising. You don't want to waste money by missing a lead or missing a good case. It also doesn't mess up your case management software by keeping it in a different platform just focused on your leads. So check out Lead Docket by Filevine. Also brought to you today by Steno. Steno is a product you've used a lot, Rahul, right?
Steno is fantastic as a court reporting company. In addition to that, if you haven't tried Transcript Genius, it is an AI-based search engine where you can ask it questions such as, with an entire case, all the evidence on negligence, and it'll pull all the deposition testimony from all of the witnesses and put it together in a seamless way with hyperlinks to the actual text. Amazing.
And if your state law allows it, you can also defer the cost of depositions till the end of the case, which is, we were just going through our budget, and transcripts from depositions is in the top 5 of our expense items. So it's worth checking that out. Our show's also brought to you by Smart Advocate. That's the case management software we use at our firm. Our staff loves it. We love it. Very intuitive, very robust, can be adapted to do a lot of different things from mass torts down to small PI firms. So take a look at that. Finally, Hype Legal is the firm that we use for our social media and for our website design and development. We just rolled out our new website about 2 months ago that was designed by Micah and Tyler at Hype Legal. We love it. We've had a lot of great response to it. So if you want to see their work, come to our site at gideonason.com. And if you like what you see, contact Hype Legal and see if they could do the same for you.
Welcome to the Elawvate podcast. I'm Rahul Ravipudi.
I'm Ben Gideon.
This is a perfect segue. I know normally we do a little back and forth banter, which is always fun, but it's been about 3 months since the fires happened here in California, the Palisades fire and the Eaton fire. And when they started, one of the big concerns that we had, having done a lot of these cases in the past involving utility-caused wildfires, was knowing what was going to happen in the community and a lot of the questions people have. Speaking from personal experience, I've never had to deal with even looking at my homeowner's insurance policy and understanding, what does it mean? What does it cover? It's got like 2 pages saying that I'm covered for everything and 45 pages saying all of the exclusions. What do I even do? And how much am I covered for? And who do I call? And questions like that before you get into the next step of, does the federal government intervene? Are they going to help me? Are there other things I need to be worried about? How old's my home? Do I have asbestos there? Is there lead? Should I be worried about my kids? Is my home standing? Is it not standing? all of those things. And so one of the things that we did is our guest, Ricardo Echeverria, and myself and a few other colleagues, we got together and we started doing public service town halls for the community because Ricardo is one of the best insurance bad faith trial lawyers on the planet. And there's nobody better to learn from than Ricardo. And so we've been spending a lot of time together, not just the inner circle induction, but really on a lot of the wildfire services. And it's so enlightening and it's so refreshing to see somebody with such good intentions and institutional knowledge willing to help the community anytime. And so I'm just thankful. Ricardo, thanks for joining us.
Oh, thank you, Rahul. It's a pleasure to be here.
Before we go kind of into our normal interview process, I'm really interested in that, what's going on with that, and what are some of the things you're seeing?
Well, from the insurance standpoint, the number one thing that we are seeing is that virtually every single person who lost their home as a total loss is underinsured. Meaning, if you add up every single nickel they're entitled to under the policy, it's not enough money to replace the home. So most of these policies we're seeing are written all in maybe $350 to $400 a square foot, where the true cost to replace is closer to $800 to $1,000 a square foot. So it creates a real dilemma because, people, and especially if they got mortgages on it, there's not enough money under the policy to cover the actual loss of the home. And there's a lot of reasons why that happens, but that's what we're trying to help people through because, there can be cases where you can hold the insurance company accountable for underinsurance limits. But that's by far and away the biggest
Hmm.
problem we're seeing with every one of these homeowners.
And is that, do you think that's unique to Los Angeles or California, or do you think if you were to look at policies around the country, you'd find the same?
You probably find the same throughout the country. The whole history of it, the way it happened, before the mid 90s, the insurance industry sold homeowners policies under a guaranteed replacement cost basis, meaning that if you had a limit, they would tell you, don't worry about it. If it costs more, we're going to guarantee the price to fix it. And in California, we went through a series of catastrophes in the late 80s and then the 90s, the Loma Prieta earthquake, the Oakland fires, and then culminating with the Northridge earthquake in 94, which at the time was the largest catastrophe the country had ever seen. And the insurance industry paid a lot of money on claims under guaranteed replacement cost basis. The industry, starting with the big three, the State Farm, the Allstates, and the Farmers of the world, switched in 95. And they stopped selling guaranteed replacement cost and they switched to only selling extended replacement cost. And the way that works is you have a policy limit and then you have an extension. It could be 10%, it could be 25%, 50. I've seen it as high as 100%. But the point is, if you have a policy, say of $1 million and a 50% extension, you're capped now at $1.5 million. Whereas with guaranteed, you're not capped at all. And the way the industry sold the policies, unfortunately, didn't catch up with that new product because many people, if they would go to their agent, they say, do I have enough insurance? Agents would often say, well, the limit plus the extension will give you enough. The problem is that's not the way you're supposed to do it. You're supposed to make sure that the base limit is enough to cover your home in its entirety at the time you buy the policy. Why is that? Because when you buy your home, you can, with pretty good accuracy, figure out what's it going to cost to replace it. What you don't know is that 6 months later, if there's a catastrophe and 16,000 other homes go down at the same time, then what's the cost to replace it? There's demand surge, there's the cost of lumber, concrete, everything goes up, contractors. So that percentage is designed to protect you against the unknown. But the way the policies are written, they're just not capturing it that way. And the other thing I will say, and this is true really throughout the country, but it's accentuated in states like California and Florida and Colorado where there's more catastrophes, is that the industry goes about as suggests the limits you should have, and most people never look at their policy, number one, and two, don't know anything about what it costs to replace a home, so they just accept the limits as is. And overall, what that does is it caps the exposure in a catastrophic event like this. So I always tell people, I do lectures to my people in the office, just like you go to the doctor for a checkup, you should go to your insurance agent for a checkup. And it's really pretty simple. I mean, you could hire a contractor just to give you an estimate. What's it going to cost to replace my home if you had to build it from scratch right now? And they'll do it, and you'll get it. I bet you'll be shocked to learn how much more insurance you need.
Hmm.
So
Yeah, we went through this exercise a few years ago. This reminds me, and probably many of our listeners will be reminded by this conversation that they better go back and look. I recall that we had upgraded our amount on our homeowners because we were way underinsured for what it would have
but
cost to rebuild, and that you can't buy a guaranteed replacement policy
yeah,
anymore.
I only knew of one company that did it in the Napa fires, and I actually sued that company for the way they handled that claim. But I'm not aware of any company now that's issuing guaranteed. It's just really, really a rare commodity. I haven't seen any arising out of the Palisades or the Eaton fire.
Hmm.
So,
So you guys taking on cases now? Both, I know
yeah,
you're doing the liability case, right?
well, I'm not. Rahul's office is definitely handling the third party cases out of the Eaton fire. We're not handling those. We're focused on underinsurance cases. So, right now, for the most part, what we've been doing is fielding calls, giving people advice on how to get their stated limits paid, because eventually they're going to get paid those limits. There might be some struggles along the way, and we can help them through that. But we already have signed up a handful of cases that will be ready to file where people have gotten their benefits, they're underinsured, and the question is, why are they underinsured? And there's the general rule in California is that it's a homeowner's responsibility to set their own limits, but there's exceptions to that rule, and those are things like if the insurance company holds themselves out as an expert and suggests the limits. In California, if they suggest the limit to you, say this is what we think it should be, there's certain things they have to do to make sure that estimate is accurate. There's a reg on it. It has a whole list of things they need to consider. And what we're finding is that, time in and time out, they're not taking into account everything. And so those estimates are unreasonably low. So we can hold the carrier responsible for unreasonably setting the limits too low. And there's other ways too, like for example, and these are not cookie cutter cases, they're fact specific. There are cases where insureds go to their agent and say, hey, do I have enough insurance? And the agent will assure them, yeah, we think that you have enough coverage. That's a representation. And you can rely on that to then switch the burden onto the carrier for, setting the limits too low. So we look at them one by one, and then what we are doing is grouping them by carrier, and we're going to be filing group actions per carrier. So that, for example, one of the carriers we know is setting limits across the board. So that's a common theme on those. And within that group, there's people who have even bolstered facts where they have the kind of conversations I was just talking about. So that's how we're kind of approaching it. And it's how we did it in the Napa fires. But you do need to be careful and selective and make sure you have a solid basis because they're labor intensive cases. But there's a lot at stake for people, especially in the Palisades, where it's going to be more challenging to get a third party case. Underinsurance may be the only way people get made whole, and that's the ultimate goal of what we're trying to accomplish: is let them rebuild.
What did you mean when you said some carriers are setting policies across the
Sure,
board?
sure. What they're doing is when you get your renewal, there'll be the declarations page and there'll be a disclaimer, not a disclaimer, but a disclosure that we have done our calculations, and based on our calculations, we think the cost to rebuild your home is X. And so they have their own system that calculates the factors and then spits out a square footage price per square foot that they think is the replacement cost. There's always a disclaimer that says, oh, by the way, it's your responsibility to set the limits. But most people see that their limits go up and their carrier suggested it, so they just go with it, and they don't think twice about it. So 15 years ago, you didn't see carriers doing that as much, where they would tell you what the limit should be. And then, but now we're seeing that more and more. So it really does bring, people don't challenge it, they just accept it. And we know they're wrong because look at real life what's happening. The numbers are far below what the true cost to replace is. So we're challenging systemically how they set those limits across the board.
Are your damages in the cases limited to the economic value, or are there other categories of damages that
Yeah,
apply?
it's different from a bad faith case because the hallmark of a bad faith case is the unreasonable withholding of a benefit without proper cause. Here, the stated benefits have been paid. So you're going outside of a contract theory, but you're going into underinsurance, negligence, things like that. I will say, however, I told you that when a carrier suggests the limit, there's an insurance reg right on point, 2695.183, that sets forth all the factors that they need to consider in coming up with that limit. And it also says that a failure of a carrier to comply with that reg can be a basis for breach of the implied covenant of good faith and fair dealing. So there's no case that's really kind of taken that to the next level, but we're going to include bad faith claims for breaching the reg, but it's kind of counterintuitive because the benefit is stated in the policy. So the theory will be the benefit that I should have had is you complying with the reg. The benefit should have been higher, so it makes it part of a bad faith claim. But for sure, you're entitled to the economic damages. Under some theories, maybe emotional distress, and then we put punitives in there, but it's more challenging than a traditional bad faith case.
Well, nothing about that seems easy, but
Yeah,
real service to people that have suffered and lost their homes and are unable to rebuild. So
right.
I'm glad there's somebody with your level of skill and intelligence that's on the job there. I'm just curious. This is such a niche area and really challenging area of practice. How did you get into doing these bad faith cases?
Completely luck. I,
Good
I,
luck or bad luck?
no, good luck. I grew up in Chino, and we have a big Basque community here. And my parents both immigrated from Spain. And Mike Bidart, my mentor, is a lawyer, and he's Basque. And so when I went to law school, I called him, and I clerked here in my first summer in 1991. And I fell in love with the practice. And so I didn't know anything about insurance bad faith after my first year of law school. Well, after that summer, I learned a lot, and I fell in love with the area, and I decided that's what I wanted to do. And I worked here my second year, and then after I took the bar, came here and worked. So it's the only place I've ever worked. And so now my practice is pretty split. I do obviously insurance bad faith, but I also do catastrophic injury cases too. They're very different kind of cases, and it's nice to have that balance. But that's how I fell into it, completely by luck, to have Mike as my mentor and an area that I really enjoy practicing in.
It's definitely seems like it'd be nice to have a real villain on the other side with a named insurance company defendant.
Yeah,
Um,
it is. It is a nice dynamic in trial. Although I will say, having tried bad faith cases now for 32 years, you ask people on the jury pool, do you have negative views of insurance companies or positive? Obviously, you're going to get a lot of people with negative views, and those people, for the most part, are people who've had significant claims or loved ones who had significant claims that were denied, and so they come in with that view. But then there are more and more people who say, "Oh, my insurance company handled my $10,000 water damage claim promptly." So there's positive views too, and the people with positive views are ones generally that have had smaller claims that get paid. So it runs the gamut, but for the most part, you're right. Insurance companies are mostly considered the villain by the average person.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. PSRplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at PSRplaybook.com and learn from the best.
So you referenced your upbringing and so forth. I saw you give a very fascinating talk about that. And you have a background that's very different from most trial lawyers. Can you maybe tell everybody about that a little bit?
Yeah, I grew up the son of Basque immigrants who came here from Spain. My father in the mid 50s, and then went back, married my mother, and then she immigrated when she was 19 with him. He was 26. And we grew up on a dairy farm in Chino, which is here in Southern California. And, people who aren't from here don't realize that back in the 70s and 80s, when I grew up, the Chino Valley was one of the largest dairy producing states in the country. And, we had at one point 400,000 cows about 40 miles from downtown Los Angeles. And that's where I grew up in that world. So we had a lot of, neighbors, all dairy farmers. And so it was a good, when you're 10, 11, 12 years old, you don't really like get up at 4 in the morning, but it does teach you a work ethic. And the good thing about it was that the commute to work was like a 40-yard walk to the barn. And we lived on 60 acres. And so my brother, my mother, father, and I, we had every dinner together. We all worked together. We all worked on the dairy. And that's kind of was my childhood. And I'm still in it, although I don't do the day-to-day on the dairy. My brother runs a dairy farm up in Bakersfield. My father's 87. My mother's turning 80 on Friday. They're still active, running a dairy farm. And, now it's milking 10,000 cows. So it's a very humbling way to be raised, but in retrospect, it's a very positive way to teach you a work ethic. And, so I was lucky in that regard. Very different from the average person in law school, that's for sure.
Did your parents want you to go to law school?
No, that was a tough conversation initially. When I decided to go to law school, I had to make that phone call. I remember I was a ag business major at Cal Poly, San Luis Obispo, and I had decided during the course of undergrad to go to law school. And I had to make that phone call to my father saying I wanted to go to law school because his plan was I was going to come back and run another dairy. And I did that phone call, and my roommate, who was also a Dutch dairy farm kid, and he was going to Texas to run a dairy, and he knew what I was going through. And my father was pretty angry, hung up the phone, and I think about 3 minutes later, the phone rings back, and my father is on the line, and he says, "No, don't say anything, but if you decide to go to law school, I'll support you because I want you to be happy in life," and boom, hangs up. And the only reason he made that phone call is because my mother was right next to him and said, "You're going to pick up that phone, and this is what you're going to say." Yeah, I just know that. Yeah, and so that's how it went. But I will say, once I got going in law school, parents are, they love their kids unconditionally, and so do mine. And so they supported me. But then it got to the point when I started practicing and I was going to trials. My mother and father would pretty much come to every closing argument I gave. I mean, they were living in Bakersfield. They'd come to San Diego, get at 3 a.m. to get there by 8:30 for the start of, but they really enjoyed, watching the closing argument, the trials. They don't travel as much now, but they really did for a while there. And that was neat to see that they're completely supportive, of course, now, but at the time it was, it was a growing pain.
When your parents would go watch your closings, did they give you a breakdown of how they thought the case was going to end up before the verdict came?
Well, yeah, they would give their 2 cents for sure. I mean, I shared a couple stories about that at the inner circle, but yeah, they come to it with a pretty common sense standpoint. They can figure out what's bullshit, what's not, and what they like, what they don't like. But and their biggest thing too is, they don't like mean personalities. So if the other side is acting that way, that turns them off, and they'll be very vocal about that when they talk to me. But yeah, they're very observant in about all things in life. So they would be good jurors, but they're good to have in your corner.
Rahul, do you know how to milk a cow?
I have no idea how to milk a cow. Actually, I don't even know if I've touched a living cow, let alone milked it.
Yeah, I haven't either. No. Ricardo, do you think there are?
And I'm lactose intolerant, so if I'm sharing too much right now, so
That's
I
all
don't know if
right.
I'd want to.
Oh my God. Uh, Ricardo, are there, I mean, aside from just the work ethic, which I'm sure translates quite well to being a trial lawyer and practicing law, are there other things you think you've taken from your childhood that translate to the work you do today?
Yeah, growing up in Chino in the 70s, we were exposed to a very diverse culture. The people who were running these dairies were, for the most part, immigrant families. I mentioned the Basques. We had a big community. There were a lot of Dutch. There were a lot of Portuguese. We had Mexican families. So we had a lot of different interactions with a lot of Portuguese as well. So we had a lot of interactions with different cultures, different personality types, and it did teach you to be very, very accepting of different cultures. And my parents were always big on that. And so when I'm in court and I'm picking a jury, in particular, when I hear somebody with an accent, because just about everybody I spoke to as a child had an accent, and these were some extremely successful business people. These dairy farms were profitable, they were growing, and so you never treat somebody with an accent and underestimate them. And so when I'm picking a jury and I hear somebody with an accent, I can relate to that person, and I can, and maybe they're a little shy, they're a little worried about being in court, and I assure them that, look, what you need here is a common sense approach, and the ability to sense right from wrong. That you can do no matter what your first language is, and you get people assured and confident that way. So that part of my childhood for sure has helped me in my practice, because if I hear, jurors, maybe they don't have the college education. My parents didn't have, my dad didn't even have a high school education. And so I never underestimate anybody because of that. And that's translated well from childhood into professional life.
And when you decided you wanted to go to law school and had that difficult conversation with your dad that you've referenced, at that point, did you already know you wanted to be a courtroom lawyer?
Yeah, I didn't really know much of what being a lawyer was, other than being a trial lawyer. That's all I saw on TV. And I said, if I'm going to be a lawyer, I want to be in the courtroom. And I kind of developed that idea in undergrad because I was the student body president at Cal Poly San Luis Obispo. And, we were big fish in a small pond of 17,000 students, but I got exposed to a lot of people in that process who were, speech communication majors and poli sci majors, people going to law school. And it was always oral discussions and stuff. So that's how I felt the lawyer should interact. I never thought of as a lawyer as sitting behind a desk, drafting a patent agreement. That's not anything that I had an interest in. And then the question was, okay, I knew I wanted to be in the courtroom, and I really had no idea what type of cases, whether it was criminal defense or civil. And then in the process of first year, where you're just trying to figure out torts and contracts and read these cases, and then it came real to me after my first summer, and I fell in love with this area of practice, and I knew this is what I wanted to do. But I will say this: the one thing I always believed, I wanted to help people, no matter what I did. And if you were to ask me today, you have the option of being a lawyer, but you have to defend insurance companies. I'd go back to milking cows. I would rather do that than practice law in that field, because that's not me. That's not my personality. So I got lucky to, get into a field I loved, and you get to help people along the way. Just like, you guys, everybody loves what they do, but the best part of our job is, the people that we help, our clients.
I go back to milking cows. I love that.
It's true. Why would you want to? I don't know. I mean, there's different strokes for everybody, and not obviously there's great defense lawyers too, but it takes a different kind of mindset to, go out defense of somebody, and then I saved an insurance company some money. That's not something I want to do.
What is your personality in trial? Is it different than you present outside? Because you've got such a calm cadence and affect to you all the time, and you're an excellent teacher, and so a lot of the things, vibe with what you communicate to a jury about common sense and right and wrong.
Yeah.
Um, do you get fired up in court, or?
Well, yeah, it goes up and down. I always try to keep a calm demeanor, a level head about myself. But, it usually comes out in rebuttal when you listen to certain arguments that are made, and then you tear those down. So I do get a little more animated when I'm talking about that. But then when you talk about damages, for instance, you slow it down and you make it real. And I try to just be the way I am in everyday life in a courtroom as well, conversational, talking to people, not at people, and try to just connect with the jury. That's the ultimate goal that we try to do. And I don't know, everyone has their own style. Mine is pretty much the same as I am in real life. It's the same thing in a courtroom. I don't put on a different persona, but if I get angry, I'll get angry, but I try to keep that in check, but just, in a controlled way, but show the jury that this is something they should be angry about.
So on your cross-examination, for example, do you have a philosophy on whether everything has to be a leading question, or do you give people rope to hang themselves with?
Oh, I break every rule on cross-examination, I think. I'll give you an example. I tell young lawyers, look, you have to be prepared to go off script when you're cross-examining because you don't know what nuggets you're going to get live in the courtroom. And I'll give you an example of one. I remember I tried a case in Bakersfield, and it was a wrongful death, and it was a truck who ran over our client in a crosswalk, and there was a grainy video from a ATM that showed it. And so we knew eventually they would admit liability. They did, but they didn't admit 100%. So we had a liability fight because they're arguing comparative fault against this pedestrian who's got run over in a crosswalk. And they had this human factors expert who goes on and on and on about, the not paying attention to the audio and visual cues of the truck and blah, blah, blah. Well, they take this witness, it's the last day of witnesses before closing argument. Trial's gone well, and they got him on the stand for 2 hours, and they get it done at 4:15, and then now it's 4:30. We cut, and the judge looks at me, and he says, "Mr. Echeverria, 15 minutes." And I look up at the clock, and I look at my notes, and I probably had a half an hour wringing wet. And I said, I'm making it seem like I don't know if I can get it done. And I said, no, I'll do it in 6. And then the jurors kind of waking up. Oh, this is kind of cool. And you get up and you close your notebook and you get out in front and you look at the doctor and say, "Doctor, there's a video of this entire accident, right?" "Yes, I'm aware of that." "And you've seen that video, right?" "Yes, I have." "And you know that this jury has watched that video too, true?" "Yes, I'm aware." "Would you agree with me that this jury can watch that video and they don't need you to tell them what they saw?" And some of the jurors started laughing, and he goes into this automatic expert witness explanation mode, blah, blah, blah. And he's, looking at the jury, like trying to teach them. And I'm just watching them. And when he turns back to me, "Are you done?" "Yes, I am." "So am I. Nothing further, Your Honor." And you just then the next day you just trash them. Why do they bring this guy in when you got a video of the accident? I mean, you can figure it out. So again, that's an example of a cross-examination that I didn't script it. He gave it to me, and you just go with it. But yeah, it just depends. Sometimes the leading question, sometimes you'll ask an open-ended question, but you got to know the witness and what the issue is and where you're going to go with it too.
Tell us about some of your cases, Ricardo.
Well, I've done so many different types of cases from the insurance bad faith world, and then from the catastrophic injury world. I'll tell you a couple of examples of each, so you can see
Before
that.
you get into that, is there a difference in how you approach those cases for trial?
Yeah, for sure. When you do a personal injury case, you have to rely on witnesses to perform, whether it be your client, the loved ones of your client, the treating doctors, the eyewitnesses. You have to prep the witnesses and they need to perform well. And you do your job as cross-examining, the defense experts or bad witnesses, whatever. But in a bad faith case, you're really kind of educating the jury. I start every bad faith trial calling every single adverse witness under 776, which is our statute of, calling an adverse witness in our case in chief. And I call the adjuster, the supervisor, the executive, everybody, and I can turn those witnesses into my expert witnesses, because the first part of the cross is educating the jury on what the rules are that insurance companies must follow. And they'll give you all that, and then you cross-examine them on the issues. And by the time you're done with that, I call it the shock and awe part of the trial. Just when the dust settles after that, you've pretty much won the case if you've done it right. Whereas in a PI case, you don't really have that. You have to go through the liability issues, but you need witnesses to it. So it's a totally different kind of dynamic. And the other thing too is when you sue an insurance company, well, when you do a PI case, many times, it's not intentional. Somebody wasn't paying attention, they had a human error, and somebody got profoundly injured. And it's a terrible, tragic story. And we have those cases sometimes where the defendant feels horrible about what they did, but they have to be held accountable. In a bad faith case, I'm not saying that there was some accident. I'm saying you intentionally tried to cheat my client out of money. So you're almost like a civil prosecutor. You're going after an insurance company for wrongdoing, and at the end of the day, you want to punish them for what they did. Now, we sometimes get that in PI cases for sure, where people are injured because of corporations wanting to save money, and you can have that kind of case. But in the insurance bad faith arena, it's always that kind of a theme. So they're very different cases altogether. But it's nice to have that mix, so you're not boxed in the one or the other. And the interesting thing is the way I got into doing both is that I get a lot of phone calls of people calling me saying, "Hey, do you think I opened up the policy?" When you're doing a case, and I would look at it and say, "Well, I think you've got a good argument that you did open the policy. Where are you with the PI case?" And so, "Well, we're just filing it now. Do you want to come in and handle the PI case?" And so I started doing the PI cases, and then I would do the bad faith case thereafter. So that's kind of how it started maybe 15, 20 years ago. But they are definitely different kinds of cases and a different approach to cases altogether.
I'm sorry, I keep asking you questions that put
Yeah,
us off track, but this is something we get lots of questions about, and I know it's different state to state, but can you give plaintiffs' lawyers a quick summary of what they should be doing to make sure they open up a file and do the right foundation so that they can set up the bad faith case?
yeah. Well, first of all, I always laugh when I hear the word setup,
I
because
knew you were going to say that.
that's the term the insurance industry always uses. And the way I view it is you have to give the insurance company the opportunity to settle within limits, and you have to give them the information they need. If they pay it, you've done your job, they paid the policy. And sometimes they don't do their job and they don't pay the policy. So in California, which is, I think, pretty consistent throughout most of the country, you need to do a demand that is within limits, that is reasonable. And that's defined as, given all the liability and damage issues, is the judgment likely to exceed the amount of the demand? So you lay out the facts. You have to give the insurance company enough time and enough information to consider it, so that the reasonable decision is to say yes to it. So it has to be a reasonable demand. And if they fail to accept that reasonable demand, and in California they have to do it unreasonably, then you've opened up the policy. But I think that to make it simplified for across the country, make sure you put forth a reasonable demand that gives enough information, enough time for the insurance company to make the right decision. And if they don't, then you've opened up the policy most likely. And but the other thing I will say about those kind of cases, and in particular in insurance bad faith, when you're trying them, it's a totally different kind of jury you're looking for. I'll give you an example of one I tried a year and a half ago in San Jose. And it was a $100,000 insurance policy where a motorcyclist made the demand. He got injured, got rear-ended by a white Honda that was the insured that had the 100,000 policy. And he wrote a handwritten demand to settle for the 100,000. Well, the police report interviewed about 6 witnesses, and 5 of them said it was the other way around. The motorcyclist rear-ended the Honda, and the insurance company interviewed 5 of the 6 witnesses, and they all seemed to confirm that that's what happened. So this motorcyclist was at fault. And there was one witness they didn't interview. And so the insurance company rejects the demand. So he hires a lawyer, files it. First witness that's deposed is that one witness that wasn't interviewed. And he turned out to be a retired San Jose PD officer who looks at the police report, which he had never seen, and said, this is completely wrong. And all these witnesses are completely wrong. I had the best vantage point. I was right behind it. And this is what happened. The motorcyclist got rear-ended and he flipped over. And I saw it firsthand. And all of a sudden you see the claim file notes go crazy. Oh my God, did we get this wrong? And they get an accident recon. And the first thing the accident recon, just from looking at the photographs, motorcyclist got rear-ended. And they offered 100. So against that backdrop, it's like an $8 million judgment. Now the PI case goes to trial. Another lawyer handled that. So I then take the case and I sue the insurance company. I have to prove that it was a reasonable demand and that they unreasonably rejected that demand. And of course, the defense at trial was, hey, look at all these things we did. We interviewed so-and-so, did this, did that, did that. I mean, they had a very robust file of an investigation. But the one thing they didn't do was interview the last witness, which was the most important witness. And if they did that, we know it would have cracked the case. And so it was that kind of a theme that, look, we did, even though we got it wrong, we were reasonable. So, normally in a PI case, you want jurors that have sympathy, empathy, who will give non-economic damages. I don't want any of that for this kind of case. I don't need the jury to give me money. That money is there with the judgment. I need people like the accountants, the engineers, the people who live with precision in their life that are going to say, if you didn't do that one thing, sorry, you didn't do everything you needed to do, you're responsible. So the analogy was kind of like if you're a pilot and you have a 100-point check system and you do 99 of them perfectly. And when you're 5 miles in the air and you got 135 passengers in the back and you go to click the landing gear, oh, that's the one thing I didn't check, and there's a disaster, then are you going to say that was reasonable? And you have to analogize the handling of a time limit demand as important as flying a plane. I mean, it is an event in the insurance world that is very, very important. If it's not handled properly, it can devastate financially the lives of the insured. You have to handle it properly. So it's a very different kind of case altogether to try from the PI.
A question on that. When they were defending the case, did the insurance company ever argue in the bad faith case that their insured, the driver who rear-ended that motorcyclist, lied to them?
Oh, yeah. Yeah. No, that's what made it even more complicated. But the reality is she didn't know what happened. She wasn't paying attention. And she was on record saying, I got rear-ended. And that's what the cop told her. And by the way, the cop who wrote this police report that was so off passed away, so he wasn't around to testify. And ultimately, when the two, the insured and the claimant, got done with the underlying case, they did a joint arrest. So I had both of them as plaintiffs, and they're pointing the finger at the insured saying she lied. And her testimony was, look, I really didn't know what happened. I explained what I thought happened, and I believed it at the time. And then she said, it wasn't until I saw the plaintiff accident recon expert come in, I realized, oh my God, I caused this accident. So it was a whole nother dynamic to it, but for sure that was one of their big defenses, is that they're blaming their insured. We relied on our insured. And to some extent they did, but they also relied on other witnesses who got it wrong too. So it was a unusual case.
One more question about this. We get a lot of inquiries. I'm sure many lawyers field them regarding denials of medical benefits, particularly for people that have a serious illness or diagnosis that need treatment, and then insurance companies are denying that. I know there's a significant discrepancy in terms of whether that's an ERISA plan or non-ERISA plan and what hoops you have to jump through. But how to, and under what circumstances would a denial of medical benefits under an insurance policy be fodder for a bad faith claim?
Yeah. Um, First of all, it has to be non-ERISA, because you can't get the bad faith benefits if it's an ERISA plan. And the exceptions to ERISA that we have are a government employee or church employee. All the medical insurance bad faith cases we've had have been for government employees or church employees. But the law is the same whether it's medical benefits or property benefits. It's the unreasonable withholding of a benefit without proper cause. Withholding, not necessarily denial. So we've had cases where a client, a patient, is recommended by a doctor for a particular surgery because they have a certain kind of cancer and they think they can treat it with a particular surgery. And the insurance company takes 4 months to approve it. And by then it's metastasized and it's too late. So they didn't deny the benefit, but they unreasonably withheld the benefit and delayed the benefit. Those cases, I will say, have been the most dynamic in terms of getting a juror angry, because now you're talking about people's health. It's not just their house, it's their health has deteriorated because of an insurance company decision or delay in making a decision. And those, but it's the same principle. You've unreasonably withheld the benefit. I'm entitled to the benefit. I'm entitled to emotional distress. I'm entitled to punitive damages if the conduct was malicious, oppressive, or fraudulent. Because, the reason that whole area of law exists, if you think about it, is the only reason it's a tort to breach an insurance policy is because the law recognizes that when you make an insurance claim, you're in a vulnerable position. When you make a claim for a surgery and you have cancer, you're depending on that insurance company to give it to you. Your life is at stake. And it doesn't do you a lot of good if they approve it 4 months later and it's no longer a benefit to you. When you get the benefits is sometimes as important as the benefit itself. So it does come into play on these medical cases for sure.
And since the vast
I
majority
rem-
of people have ERISA plans, they're out of luck in terms of any kind of
Yeah.
claim of that sort. There's nothing you can offer them.
Yeah. And I don't do ERISA cases, but the remedies under ERISA I know are limited to the benefits and maybe some attorney's fees, which in a case, like I said, of a delay of benefits doesn't do you any good. Getting the cost of a surgery after the fact when it's no longer going to do you any good doesn't help you. So, yeah, we routinely have to turn down ERISA cases. It's unfortunate, but that's the reality.
So I remember I actually don't know if I've ever told you this, Ricardo. So 20-ish years ago, Mike Bidart, your partner, was going to be an expert witness on one of our cases. And so I was in your offices in Claremont. And then as I was talking to Mike, he's like, "Hey, can you hold on for a second? My Ricardo in my office, he's in trial down in San Diego, and I think he's got a verdict." And so then the verdict happened. And so then Mike was so excited. He told me a little bit about the case. He said, "So Ricardo represents, and if I've got some of the facts off, it's been 20 years, but I think I'm close." And so he goes, this person, a Navy officer, had a
Yeah.
home and there was water damage, and it was like $30,000 in water damage. And he made a claim with the insurance company, and the insurance company wouldn't pay it. And so Ricardo went to trial, and in my mind, I was like, okay, I mean, I get it,
Would
but
do.
I mean, is this a big case? But the conduct was so egregious. You got over $3 million in punitive damages on the case. So is this 3 point something $1 million verdict on $30,000 in water damage? And that was, for me, my first even exposure, even understanding the world of insurance bad faith,
Yeah.
was something you did down in San Diego, and it was jaw dropping. It was amazing.
That case, the only correction I'll have, it wasn't a Navy officer. He was a Force Recon Marine. And this was back in the mid 2000s. And I remember it vividly because when the new case eval came in, it's 30,000 water damage claim, and it wasn't a big, but Bill Shernoff saw that it was a Force Recon Marine who was calling from Afghanistan to our intake department. And he says, Ricardo, you need to take that case and you need to try it. So, okay, those were my marching orders. And when we looked at it, on the time, it was beyond statute. And I remember when the Force Recon Marine came back and I had to explain, let me do some research. Well, there's a thing called the Soldiers and Sailors Relief Act, so that when you're deployed, it tolls the statute of limitations, and that then brought it within statute. And so when we tried that case, it was all about getting punitive damages. I mean, let's face it. I mean, I'd spent a lot more than 30 grand on the case to work it up, but the conduct was really bad. And I'll never forget the one thing about that case, the different inside story. When we were picking the jury, she was juror number 6. I remember her vividly. And she's just standing. She's so into it. You could tell she's got sitting forward. And I got to her. I said, ma'am, what do you do for a living? She's a young gal, probably, late 20s, early 30s. And she says, I'm an insurance adjuster. Oh, and how long have you been an insurance adjuster? She said, 2 years. And who do you work for? Geico. What do you do at Geico? MedPay. Have you ever done anything other than MedPay? No. And then she volunteers, says, but I'm switching professions. I'm going to be a personal trainer. So I'm going through thinking, okay, number one, she's only been in it for 2 years. She's only done MedPay. So all she's done for 2 years is rubber stamp $5,000 payments day in, day out. She doesn't deny a claim. And she knows the rules that apply to insurance companies. So I left her on the jury. And the defense lawyers, well, thank you for doing that. And ultimately, she was our best juror. And she was so offended by the conduct. She was the one that brokered the punitive damage verdict. She wasn't the foreperson, but she was the one that made sure that there was a punitive award that would send a message. And so, again, it's kind of cutting against the grain to leave an insurance adjuster on a bad faith case, but it worked out in that case.
Ricardo, so I wanted to ask you, I can't not have you on the podcast and leave without this happening, but you're obviously famous for everything you do in the courtroom and the results you get for your clients, but you're almost equally as famous for some of your amazing impersonations.
You can't make me do this.
Oh, yeah. Oh, yeah. So, I mean, I know Brian, you do an amazing Brian Panish impersonation, but you got to do at least one of something
Oh my
that's your
God.
go-to.
Now you're going to embarrass me. No, I remember this goes back, maybe 15, 20 years ago. And I was trying a case downtown on the 4th floor at Mosque. And Brian was trying a trucking accident case, also on the same floor. And we would see each other in the cafeteria. And so I get done with my closing and I'm babysitting the jury. So I go over to watch Brian. He's finishing up his case. And I think it's the last day of his trial before closing. And he's got this trucking expert from North Dakota. And he's cross-examining this trucking expert. And I've never seen a lawyer take an expert witness from leaving his house to getting to downtown Los Angeles in more detail than Brian. And it starts off with something like, "Bet you live in North Dakota, is that right?" He goes, "Yes, that's right." And he goes, "Bet there aren't, how much you charge for travel time? How much you charge for travel time?" And he's like, "Well, I charge $200, $200 an hour for travel time." "Yes, that's correct." "Bet there aren't any airports by where you live in North Dakota, are there?" And he's like, no. How long did it take you to get to the airport? Well, it took about, 3 hours. 3 hours to get to the airport. You made $600 before you even got patted down by the TSA. It continued from there. I'm gonna go into the rest of it, but I mean, it was just like one thing after another. Oh my God, he just destroyed this witness. It was so entertaining, and the jury's just loving it. I mean, I can see why Brian gets these huge verdicts because he's so authentic and he's so in your face, but he's also so genuine, and they could just see through it. It was hysterical, but. I could go on, but I don't want to take up too much time.
So good. So good. Uh, um, so just a couple of other things. I guess, a little. You were president at San Luis Obispo. You were president of CALA, the largest plaintiff trial lawyer organization in the country. And coming up, you have volunteered your time and you're going to be in a mock trial for the Los Angeles Unified School District. We've got about 200 plus high school kids coming over to LA Superior Court into one of the giant courtrooms. And we've got some of the best trial lawyers in the country who are volunteering their time on both the plaintiff and the defense side to do a mock trial of a real trial, actually, the Stowe versus Dodgers case, where Brian Stowe, a San Francisco Giants fan, got uh, beaten very, very badly and severely brain injured from some Dodger fans in the parking lot. So tell us a little bit about that and what the game plan is.
Sure. Well, I mean, it's obviously the theme of the case. I mean, the is that the Dodgers didn't properly have proper security outside the stadium. And it's interesting when you look at the photographs, Dodger Stadium inside is so well lit up, and the parking lot is dark as can be. There's no lighting, there's no security, and they didn't invest the money in it. And so the point is they're blaming the Dodgers, are blaming the plaintiff for being drunk and obnoxious, and the assailants for being drunk, obnoxious, and violent. And the point is that how did they get drunk? Drinking your alcohol. And how much money did you make by selling them that alcohol? And the point is, when you invite that many people into an event, you have to be prepared to deal with what happens. People drink, they get drunk. When they get drunk, they do dumb things, and they can do really bad things. And it's a cop out to just say, oh, these people did very bad things and hurt Brian Stowe, who was also drunk. You need to properly prepare yourself to deal with that. And, so it's that kind of a case, similar to kind of, like in a molestation case where you have a perpetrator does a very bad thing, but the school district, it was on their watch and they should have made sure it didn't happen. So it's a negligent security case more than anything else. So I'm still working through, I'll put the closing together. I just realized I only have like 15 minutes to give the entire closing, but it'll be enough. It'll get the point across.
Well, it definitely will. It definitely will. And the cases like this where the defendant actually creates the harm by
Right.
over serving and then doesn't protect against the harm.
Right.
You've got some good arguments. It'll be
Yeah.
fun.
No, I'm gonna
Thanks
be
for doing that.
I'm gonna be calling you and picking your brain for sure. I've got a couple others too. I always pick people's brains and come up with ideas of my own and test them and kind of put it together to make sure the themes all work.
No, it'll be great as usual. Well, Ricardo, thank you so much for joining us. I'm gonna say see you soon because we want to have you back on the podcast soon too, if
All
you're up
right.
for it.
Well, I appreciate you and Ben and all that you do, and it's been an honor to be here. And thank you very much. I appreciate it.
Absolutely. So if anybody wants to reach you, how do they reach you, Ricardo?
Well, my email address, recheverria@shernoff.com, or my office number, 909-621-4935. Email's the best way, though. I always respond to emails.
Thank you.